What's up, everybody? What's up? What's up? What's up? And as you come in, hit that like button. And don't forget, if you're on YouTube, we got Super Chat running. So let's get going. And hopefully, the second half of today will be a hell of a lot better than it was this morning. And I hope it's nice and crispy on the YouTube end. All right, I just got my first notification from YouTube. Welcome you guys on Facebook, Instagram, and Periscope. So get ready to check it. And once I do that, we'll be ready to go. So give me 1 second. And yes, let's see, make sure we ain't got the choppy chop. And yes, we have got the choppy chop. I have no idea why, considering the speed I have on this thing. This is absolutely ridiculous. I got glitter on my face. What's going on? Hello. What's up, people? What's up? What's up? Everybody coming in. All right. Well, hopefully YouTube get this shit straightened out. If not, we just gonna make it do what it do while we doing it and keep it done. All right. Earlier this morning, I did a show where I spoke about the Apple TV series Defending Jacob. It was really chopped up, didn't come through very well. So I'm gonna have to put up a different episode sometime later. But what we're doing now is what I normally do on Sundays is a question and answer session. The problem is I'm not doing a question and answer session today because most of the time I haven't got very many people to give me a question. And B Nard, appreciate you for hitting the cash app. What we're doing today, because I was asked a question, and by being a question and answer session, I'm going to answer that question because it came from a long-time subscriber and donor. And so what I'm going to do as I get into that, I'm going to encourage everybody to like the show, subscribe to the channels, click the smiley face if you're on Facebook. Go ahead and hit the like button as you come in, tag somebody, leave comments, even snide remarks. I welcome all that. So I just would like for you guys to let me know what I need to do. Any kind of question that you have that deals with law. Anything other than that, hit me on the DM and we'll go from there. But today will probably only be maybe 30 minutes. More likely not. But if you have any questions at the end, chime back in, let me know what they are. Because if it's on, especially if it's on the content. So I want to make sure everybody has a firm grasp of what I'm talking about. So that way it makes it easier to apply when we're doing it. So now the question and answer session is basically, I'm going to go through and answer the question of my stance on Kansas v. Glover. And it was decided April 6, 2020. So it was a very, very, very recent Supreme Court decision, which is actually less than 30 days old at this point. But what it does, or what the case pertained to, was the police had the ability to use license plate readers to perform a traffic stop. And basically, it's basically one of those things where if the registered owner of the conveyance or vehicle has a suspended license, they use that as a pretext for the traffic stop to actually note that it's in there. But one of the things that you have to understand is the important note that's being brought in. And even if you read throughout the entire case itself, what's up, driver? It goes through something that was asked probably a couple months ago. Because there are Supreme Court cases that state that the traffic stop itself can be used as a pretext to stop. But then you forget about the other aspects of their procedures. So when you're talking about this, the Fourth Amendment issue that it brings up is your right to locomotion. And the privacy issues because they're going to ask for a driver's license. And maybe it's me. It might be, I think it might be me. Because I'm still circling over here. I don't know why. But, oh, shit. And I got glitter. Why is nobody telling me I got glitter over my face, man? See, I'm trying to get some things done. Y'all ain't even let me know what's going on, man. But anyway, what I want to go into today is the important fact that even when you're looking at the Supreme Court case, at no point in any of these cases where it relates to the traffic stop itself does it state that the traffic stop or the reader is spoken of as probable cause, or is it spoken of as a crime. And that's where we talk about the separations and the understanding of what it is that we're going through. And appreciate you, driver. But that kind of takes away some of the things that are programmed in our heads, because that's one of the things that I constantly speak about. And hold on for 1 second. Stop. How about y'all be quiet? Actually, I'm working. I'm literally working. These all fine dining. Got some little children, man. All right. Now, back to business. But the importance is to note that the stop itself is not considered probable cause, or is it stated as a crime. Even if you look at one of the videos I showed before, I believe it was with Diamond 24K, and I showed where they were stopped and the officer begged pretty much to, can I frisk you? Can I frisk you? Can I frisk you? Can I frisk you? And like, no, because again, and I put up the actual reasons why he couldn't do it, and it's because of Supreme Court cases that dealt with Terry v. Ohio and the officer having to point to the dangerous area in order to actually be able to lawfully search someone. Because I always tell people, a police officer has very limited power, simply because they either need your consent or you to fuck up, or they need a judge to make a determination for them. They are never put in positions where they can actually think for themselves, simply because we also gone through the Supreme Court case, which was probably about 1.5 years ago, where I spoke about, I did not speak about it. I spoke about something that was in the comment section that related to it. But a young lady had put up the Supreme Court case that showed the hiring practices of police officers are using those that are below average IQs, and in the sense of being able to control them. Because if you're looking at someone that doesn't question a lot of things, they're able to perform, because this is an issue for revenue generation, not about law. And I say that over and over and over and over and over again. But for whatever reason, the cogs in the machines have you programmed to believe that everything that's done, said, or pressed is right. When I'm pretty much showing you. I think that's the reason why I'm doing what I'm doing, because I want to show you what the real thing is. Because the application of law, aside from the thought of what it's supposed to be, is what we need to actually be pressing for. Because it's understanding how to apply these things that we're given. Because the great part of the argument that was made with the Kansas v. Glover case in April 6, 2020, it was the data illustrating that this tactic was being predominantly used in disadvantaged areas. And all of us understand the verbiage of disadvantaged. Disadvantaged is generally looked at as someone that doesn't have an advantage. Or in this case, it's the poor, because I talk about the war against the poor because it's not about law. It's about revenue generation. You're either going to pay for it with time or you're going to pay for it with money. And most people do the simple thing by giving up because they're dealing with convenience. And when you're talking about doing something for convenience and you're talking about doing something that deals with, I just want to leave it alone. I don't want them bothering me. These are things that disrupt your being, not only from the time that it happens, but from the time that you actually allow them to do this. Because whenever I talk about this, I talk constantly about challenging every aspect of the stop, challenging every aspect of things that come within it that you are allowed to challenge. But when you're talking about the policing in affluent areas versus the policing in disadvantaged areas. Now, just to give you an idea, we look at things even in Atlanta. The way they police in Roswell is far different from the way they police in Fulton County. The way they police in DeKalb County is far different from the way they police in Dracula. All of these are areas that have a heavy police presence. All of these have places where there are people with money, there are people without. But in the context of dealing with them, there is a difference because there's even a more aggressive nature when you're dealing with someone that is disadvantaged because it's almost the animal in a corner type deal. And they're preaching and even professing when you're talking about a lot of people got upset with Michael Bloomberg when the statements came out, something that he said that he was actually regurgitating from the previous mayor, which was Rudy Giuliani, who put in place the stop and frisk. But it was the context of minorities and poor. Copy and paste it 95% of crime because that's the way it's pushed because they believe those that are disadvantaged don't have the mental capacity to actually push forward and do something productive. So they put them in places or means of not being able to flourish or continue being disenfranchised. And a lot of the cases that was referenced in here, I'm only going to give you maybe 4 or 5. Well, it's US v. Jones 565 US, and it's a 2012 case. I did a minute case on this, but it's the police can't use or install GPS data devices or trackers without a warrant. And if done, now here's the context, because again, even I talked briefly about the radar gun, even if you're caught speeding, you can attack the chain of custody, you can attack the radar perception, you can attack the actual gun itself. You can actually bring up the maintenance schedules, the calibration schedules, the calibration requirements, things that are done that are very specific to any individual or any actual gun. But this is one of the things where I talk about you get copies of the warrant, you get copies of the warrant application. But when you're talking about getting GPS data from either a cell phone or a tracker that's placed on a vehicle or in a on someone's person, another aspect is what they call officer notes, because these are things that are going to be given in order to work as convincing a judge to sign off on it. And even if that does not happen, generally they'll do it anyway and then look for loopholes around that. But the straight and narrow on it is you have a third option, which would be the officer notes. But you use all of them in conjunction with one another because any discrepancies within the notes to the application to the warrant itself, all of those things not only have to be specific, but they have to be place, person, and crime specific. So any discrepancies, those can all be challenged. Just like Riley v. California. Police cannot use cell phone data or cell phone locations in order to track a suspect. Because again, that works simply under the same exact GPS requirements. Because at the end of the day, you have the right to be privacy within your person and effects. Both of those are dealt with when you're talking about GPS tracking, your day-to-day movements, your emotions, the conversations that you're having, which for the most part, most of us know that because we have cell phones, that's been tracked anyway. but it's the deliberate actions that are being that are able to be challenged in this aspect. Then we have Carpenter v. United States. The police cannot use cell phone towers to track one's movements without a warrant. That's another one of those where a lot of times what they're doing, they're trying to link up people. And this is one of the common things they use if you're ever charged with RICO, or racketeering influence corrupt organizations, RICO. Because what they're trying to do is link a group of people together. And this is something I believe, I'm a movie guy, so I watched The Town. And you look at Ben Affleck, one of the things they used was Carpenter v. United States. And that was also something that was brought up during the movie. Because the difference was when Ben Affleck brought it up, he understood that's what they were using. He understood that's how they were going to connect everybody, which is why they maintain certain aspects of their normal lives. But then, because even I had a young lady that I dealt with, and she's in Canada. I think I spoke about her yesterday or the day before. Spoke about her a little while back. But that's where the context of Byrd v. United States 584 US, and it's a 2018 case. But it's a case that I made more reference to when I dealt with the rights in a rental, because it comes from a Georgia v. Rudolph case. Oh, excuse me, Rudolph. Georgia v. Randolph case, and that's 547 US 103 2006. And in the context of this, it's one of the greatest examples of possession is 9/10 of the law, because you have rights in the rental even if your name is not on the rental agreement. Just like they cannot come into one's home just because the person that's allowing them in is not an occupant. Because in Randolph's girlfriend allowed for that to happen. They found stuff. Randolph's girlfriend wasn't an occupant. She couldn't allow it in. Even if it's a roommate, they have to have specific things that are done within the warrant that allows them to do these things. But if it's not there, they can't. And these are things that leave you the ability to challenge them. And now, to start wrapping it up a little bit, and I'm going to give you guys a chance for questions. And I appreciate you guys coming in, hitting that like. Appreciate you guys for hitting that Cash App. You can hit that super chat or any of that other good stuff. The links will be up after the video anyway. And everybody on Facebook, Instagram, and what is it, Periscope, Twitter, you guys, the links will be on the video on YouTube, and they'll probably be going up later. So I appreciate y'all as well. Like, share, notify, hit the bell, do what you have to do so you can know every time that I go live, because unfortunately I'm gonna have to do this a lot more. But anyway, when I speak of Ren v. US 517 US 806 1996, because that's what is basically perceived the infraction which makes the stop legal. And this is a huge part of the legal system and the destruction of the modern family constructs through child support. Now, I'm only going to touch on this because this is something that a lot of folks don't think about. But when you're talking about Kansas v. Glover, Kansas v. Glover is basically one of those cases where it's saying, hey, if the registered owner does not have a valid driver's license, we can stop this conveyance, right? Now, most people, most men, now I know there are women out there that are on child support, but I'm speaking specifically for the men. So when you're talking about most men and they're on child support, let's say you get in arrears for whatever reason because you're finding it difficult to get work, or your payments are higher than you're able to handle because of whatever reason, maybe a job change, maybe a situation change, maybe you had the COVID-19 and you had to be in the house for a month and a half and you didn't have a job. Well, guess what? The payments are going to still be required, still going to be needed. The system keeps running. Whether you can make the payment whatever way, however way, it's going to keep running. And not everybody gets a stimulus check. And Let's say you're one of those people. Because if you got one, you're not getting it anyway. But let's say you're one of those people that didn't get one and you got trapped in this system. Now you're understanding the first thing they do is suspend your license. Well, that makes it a little bit more difficult to get to and from work because now you're not able to do it in a quote unquote legal fashion. Then we go into the constructs of because you have to find other means now of getting to and from work. There are some insurance companies that will cancel your insurance because your license is suspended. So now not only are you driving without a license, which is something that's very common, you don't have insurance. So if there's even an accident, now it becomes criminal because you basically the needed liability the needed money set aside to accept the perceived liability from any accidents that may or may not occur. And then this puts you in a further disabled place because if you're stopped, now you have to spend time in jail, locked up for whatever reason, and now you're sitting there. Even if you're released after a week, there's a good chance your job's not going to be there. So you're going to have to now find a means to find a job and find a means to produce money. And you're going to have to find a means to actually put a roof over your head, feed yourself, and still be able to get back and forth to a place with no license, and barely something of a job. And then now it perpetuates the system itself because it's about the whole cycle of control and manipulation. This is one aspect why it's put into place in the means that it is. Because even in the context of Ren v. US, there are several things, because even in the video I showed with the Nevada police acting up, Hybel v. Nevada speaks of something that they must articulate a crime. And I just told you that Kansas v. Glover didn't state that the stop is a crime. But the statute states must articulate a crime, which the traffic infraction is not, before you have to even offer your first name. Because keep in mind, they're going to tell you some BS, because just like in that video, you're going to say, we need your first, last, and date of birth to look you up in our system. That's not law on any aspect, because okay. Because when you're dealing with it and you're talking about the aspects of they attempt by saying we need your first, last, date of birth and look you up in our system. It's not law, nor is it how the statute itself reads. And any state statute that is not in agreement with federal statutes or Supreme Court decisions are not valid. The selective incorporation doctrine. This is something that I've shown you several times. And even through the context of showing Ren v. US did not state a traffic infraction is a crime. And no Supreme Court case states a traffic infraction is a crime unless there's damage to person or property. And also to be noted, Terry v. Ohio speaks about must articulate a crime, must be able to illustrate what's going on or an ongoing threat, or be able to point to a dangerous area to actually pull up to pat one down, or they need your permission. Because even in that instance, you have the right to remain silent via Florida v. Royer. Because we have an adversarial system. You have the right to confront your accuser. Your accuser must have an injury fairly traceable to your actions. Your accuser must be able to prove you had an intention to cause the injury beyond a shadow of a doubt. And you have the right to challenge the evidence and character of witnesses against you. Because it's time for us to exercise. It's time for us to stand up, throw down, and be ready to die for that shit if that's what we think is important to our freedom and liberty. Because these things are important. And I spoke about this a couple of times. We're in a state where they have not been working. The machine has shut down for 30 plus days. And going through this, we're going to get to a time in which they're going to escalate because they have to make up that revenue. They're not going to miss money just because the courts weren't open for a month. They're not going to miss money just because they wasn't pulling people over and lining people up for a month. Because here's the one thing that was funny to me. I found this kind of hilarious because Monday, the state of Texas supposedly went on a mandatory mask, blah, 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 blah. I bought me a little pretty mask from the face mask shop, USA.com. And I'll put that down in the description as well. Got my little Falcons mask. Unfortunately, I've yet to wear it. Now, am I if I basically it's a conscious choice for me to not do it. I'm not advocating don't put on a mask. That's your own choice. You accept the responsibility for your choices. But I'm saying I'm not. But at the end of the day, so Monday I actually went to the store right down the road, and I saw, in Walgreens, the workers had their masks and gloves on. And then we talked about it was a police officer that was in there. And I kind of laughed because none of the customers had on masks. And prior to that, I also had a conversation with Abbott. But that was, it was kind of brief. I pretty much didn't expect anything from it for the most part because I'm nobody. And pretty much what I'm talking about shouldn't carry any damn weight. But it is what it is. But I asked the police officer, I said, with you having this mandate, there's at least 10 people in here that's not following the mandate. Are you going to enforce it? He kind of smiled and he used the words, yes, the order is in place. Yes, I have the option of doing it through officer discretion. And it's something that I speak of constantly because they too have to follow law. And if they do not, they accept responsibility for their actions. But it's up to you to hold them liable for the things that they do when it's not lawful. Because if you don't do it, you're telling them what they're doing is correct and you are condoning their actions. That's what makes everything else dangerous behind that. Now, today was kind of quick because that's all I got for right now. I appreciate you guys. Keep sharing, keep commenting, keep donating because the channels keep growing. The community section's up. And what I'm doing, I'm putting a couple of things in there. But what I'm going to actually start doing is putting, some stuff on Instagram and Facebook for YouTube, which is actually for the member section. And the membership section is going to be tier related, just like I spoke about with what is that? Patreon. Still going to do Patreon for those that have already signed up on Patreon, but what I'm probably going to do is have you guys shift over to YouTube once everything is approved. Because I was hoping for it to be approved by May 1st. I guess there are a couple changes I probably need to make because I normally don't get it right the first time. But at the same time, let's keep looking in the community section. I'm going to be posting a lot of stuff there. I'm going to do things that keep you guys informed. Things are going up on my Instagram, which are going to actually kind of shift you around to where you need to be at. It's going to give you notice of some of the things that's there and some of the things that's going to be somewhere else and what things that are going to take place. Because while the plan was originally to do a kind of a conference tour towards the middle end of the summer, and PayPal is fine. I'm probably going to have to do it either early next year or right after Thanksgiving, and probably I'm going to do one, and I'll do one big one. But it'll probably be somewhere to be determined. But right now, I'll probably either be in Florida or California, one of the two, but probably Cali. So, but everything is going to be out there. I'm going to lay out everything. I'm going to be doing merchandise. I'm going to be having shirts. I'm going to be having different things. But I also want you guys to leave comments. If you feel the stuff that I'm giving you is important, share it in groups, share it with your friends and family, share it with people that you think need it. Because at the end of the day, the information itself to me is important only because there are going to be aspects and times that maybe you don't need all of it because there's almost 300 videos in the podcast itself. But just because we don't need it right this second doesn't mean that it won't be a time where it is needed. And just because you don't need all the aspects of it, don't mean that you don't need one or two of them. So keep that in mind. I love you guys. Let's keep going. Let's keep growing. Supreme out.